and Mr. Zhang. We also have Ms. Carmen Leung, Senior Superintendent of Police Cybersecurity Forensics and Training, Cybersecurity and Technology Crime Bureau, as well as Ms. Candy Chan, Assistant Commissioner Project Governance and Cybersecurity from the Digital Policy Office. Before we resume clause-by-clause scrutiny, I'd like to report to members. The Bills Committee invited the public to submit written submissions between the 7th and the 21st of January. The Bills Committee has received a total of 18 submissions. 13 submissions were submitted by organizations. 5 submissions were submitted by individuals. All of them have been uploaded onto the website of the Legislative Council on the 22nd of January. They have also been circulated among members for reference. The administration provided a reply not long ago, at around noon today, provided a consolidated response to the Bills Committee. I'd like to invite Ms. Viga Wong, Deputy Secretary from the Security Bureau, to walk us through the consolidated response. Please also allow some time for members to ask the administration questions. The relevant paper is CB-2157/2025-01. Deputy Secretary, when you're ready, please take us through the consolidated response first. I will now open the floor to questions. Members can press the button to request to speak. Ms. Wong, the floor is yours. Thank you, Madam Chair. Do you want me to take members through the consolidated response? Or should we start with the other response first? Well, we'll first of all hear from you about the consolidated response on written submissions submitted by the public. Thank you. All the 18 submissions have been forwarded to us. We have already provided a consolidated response. We are glad to see that the majority of the submissions in general supported the legislative framework. All the opinions are quite technical. Some of the submissions say that the safety requirements aren't sufficient. They said we should increase the level of requirements. We emphasize the legislative intent of this exercise is to set out the basic fundamental requirements. The operators of critical infrastructure CIO have statutory responsibilities. We have drawn reference from different jurisdictions, the recognized standard adopted by the information security industry, as well as the existing practice of different sectors in relation to protecting critical infrastructures. If we are to enhance the level of requirements in our dialogue with the industry, we understand there are more stringent requirements, but the standard set out by the administration is the basic fundamental requirements. We don't want to incur extra costs if we set the requirements too high, so we consider the existing requirements suitable. DS. Just a second, DS. Mr. Lai has a question. Thank you, Madam Chair. I have read the submissions. The standards they require are in line with the international standards. Are there any international standards? You refer to industry standards in your consolidated response. Are you referring to the standards adopted in Hong Kong, or are you referring to the standards adopted by advanced economies all around the world? DS. Thank you, Madam Chair. Thank you, Mr. Lai. Regarding the three categories of statutory responsibilities or obligations, we have drawn reference from different jurisdictions. For the three types of obligations, in the Legislative Council brief we provided to the Council, we have drawn reference from the practice adopted by different jurisdictions. If Madam Chair agrees, I won't repeat every single one we made reference to. We have drawn reference from different jurisdictions as set out in the Legislative Council brief. Broadly speaking, the standards we have set up reflect the international standards. In the future, we may detail more requirements in the COP. I'd like to manage the time well, so 3 minutes for each member, questions and answers included. Dr. Johnny Ng. Thank you, Madam Chair. Apart from standards, submissions mentioned rules and regulations. Multinationals were mentioned in submissions. Potential conflicts well, that is to say, legal in one jurisdiction but illegal in another jurisdiction. That is a cause for concern in some submissions. Do you have similar examples to share with us? DS. Thank you, Madam Chair. Thank you, Dr. Johnny Ng. In our reply, on page 2, we have summarized our response under the category of engaging third-party service providers. There may be difficulty in complying with the obligations under the bill owing to the legal restrictions in overseas jurisdictions. Indeed, the systems in different jurisdictions vary from one to another. We cannot make a sweeping generalization. We will continue to liaise with the stakeholders and the industry. Those who have third-party obligations cannot outsource their obligations. We may provide more detailed guidelines in the COP for the reference of the industry. Thank you, Ms. Doreen Kong. Thank you, Madam Chair. I'd like to write on members' points. Just now, the DS mentioned that they would provide more guidelines in the COP when conflicts arise. But then we'll have to wait until the announcement of the COP. Otherwise, operators won't know the details right now. What if some contracts are about to expire? They don't want to breach this ordinance. They want to prepare well. So in this regard, what can you tell operators in order to give them peace of mind? Otherwise, they may feel worried. For more complicated systems, probably they are in overseas jurisdictions. So what can they do? They have nothing to comply with right now. DS. Thank you, Madam Chair. Thank you, Member, for your question. We cannot detail the requirements in relation to different jurisdictions or different CIOs. In parallel, we are conducting different work conferences. We are maintaining a close dialogue with the industry. We'd like to have a full grasp of the situation of engaging third-party service providers. When they know the requirements of this ordinance, they will have to check the laws in the jurisdiction in which they engage the third-party service provider. That's how they can make arrangements. When they enter into a contract, how can they make sure a third party will comply with the provisions of the contract so that the CIO will comply with the legal requirements? And when the ordinance takes effect, depending on the business and the preparedness of the operators, we'll designate that operator per se as a CIO in phases. Even if a company is engaging a third-party service provider and cannot meet all the requirements right now, we'll help them make the relevant preparation by maintaining a close dialogue with them. Next, Mr. Ambrose Lam. Thank you, Madam Chair. In relation to the international standard, as mentioned by Mr. Lai, oftentimes international standards refer to the standards adopted in Western countries. What about our country? What about the standards adopted by our country? Thank you. Yes, indeed, we have drawn reference from our country's practice. Apart from the US, the UK, and other Western countries, we've also drawn reference from our own country's practice, including the setup of a commissioner's office to monitor the implementation of the bill. There are relevant requirements in mainland China. In the designation of critical computer systems, what factors need to be taken into account? We have drawn reference from the US, the UK, Australia, and the EU. We have also drawn reference from the mainland China. In relation to investigation powers given to the Commissioner's Office, we have drawn reference from other jurisdictions, including mainland China as well. So in answer to a member's question, yes, we have drawn reference from our country. It's my turn to ask questions. Just now, Dr. Ng and Ms. Kong asked you questions, and I believe we'll get to that in the 8th point. That is in paragraph 8. Owing to the legal restrictions in the jurisdiction, operators may find it difficult to comply with the obligations. I'd like to hear from the administration. Operators may operate in different jurisdictions. But when they are in Hong Kong, of course, they will have to abide by Hong Kong laws. When conflicts arise, there may be conflicts of laws. Whenever there are conflicts of laws, if it means that one doesn't have to abide by the laws of Hong Kong, well, it basically means that we don't have to devise our own laws. We don't have to make our own legislation. When we go to overseas jurisdictions, we'll have to abide by the laws on the related jurisdiction as well. That's why we have international legal consultants, advisors to assist different clients. In paragraph 8, DS, you mentioned this point. Can you tell us more about this principle? Yes, that is correct. The CIO must comply with the legal requirements. Whatever difficulties they encounter, they will have to comply with our requirements as well. They cannot use it as an excuse not to abide by our ordinance. Instead, we expect that we can have an earlier dialogue with the operators. That way we can see if we can make earlier preparation or what we can do in order to fulfill the legal requirements. As Madam Chair said, after we have made the law, we cannot allow the other side to use the law as an excuse or to use something else as an excuse not to abide by the law. Say the third-party service providers will have to consider the situation. In other words, the operators will have to comply with laws of Hong Kong. Thank you. Let's proceed to the fourth paragraph. Some submissions require that the administration doesn't constitute the invasion of personal privacy and company secrets. We reiterate in previous Bills Committee meetings or in the Legislative Council brief, one of the legislative intent is that it in no way targets personal data or trade secrets. Will only require that the CIOs perform the functions and meet legal requirements. So the ordinance in no way targets personal data or trade secrets, and that's our position. Mr. Ng Kong has pressed the button. Mr. Ng Kong. Thank you, Madam Chair. In different parts of the ordinance, we request that the operator provide information. Warrants can be obtained from magistracies in order to obtain some certain information. The DS mentioned one principle. That is, the ordinance in no way targets personal data or trade secrets. When these two are at conflicts, which one will take priority? How do we ensure citizens and operators have peace of mind?
Deputy Secretary, thank you, Chair. Thank you, Ms. Kong. The principle is that we will not target at personal data. So in the definition section, we may have a wide definition, but we have not ruled out personal data there. Because we're not trying to target at that, maybe I can illustrate that with an example. If the commissioner has to deal with an incident, he may have to enter the office of the operator to investigate about computer incidents. Then he may require the production of the password for the computer, because otherwise he cannot access the system. So the password may be considered as personal data, but here we are not targeting at personal data in order to get the password. Our objective is to deal with the computer incident, and we need the password so as to access the computer. So under this scenario, I would like to explain that under the ordinance, the information to be provided would have to comply with the functions to be carried out by the commissioner, and we are not targeting at personal information. So we don't have a specific requirement for provision of personal data if there is no computer incident to be investigated. For example, like information on the customers or like the passwords. So normally, we will not require such information. So during the normal situation, we would only ask the operator to fulfill their obligations under the 3 categories of obligations and have to provide the information. So I hope that the information I quoted will enable members to understand that we are not targeting at personal data, but we have not stated out clearly that personal data will be excluded. Ms. Kong? So if I am an operator, when I provide the information to the commissioner, can I delete some of the information or maybe black out the documents, say information concerning commercial secrecy or my customers? So is it possible to have sanitization of the documents or redact the instruments? Well, I think it depends on the specific requirement of the commissioner and the situation of the particular case in point and what is the purpose of the information that he is trying to collect. So I cannot say across the board whether it is possible or not possible to do so. Maybe I'll defer to my DOJ colleagues. Mr. Leung? Thank you, Chairman. Thank you, Ms. Kong, for the question. In the bill, we require the production of information, and we also specify the power for investigation by the commissioner. So we all have set out conditions for exercising such power. For example, the request for such information will have to be related to the inquiry being made. When we go to the subsequent sections like Part 5, we will be able to touch on the powers. You can see that we actually have very stringent requirements, and they may have to take into account public interest and proportionality tests, etc. So for the individual case, the information to be collected will be subject to a stringent requirement and a stringent scope. To respond to Ms. Kong's earlier question as to whether the operator can redact some of the information when providing information to the commissioner, I think it depends on the request to be issued by the commissioner. So it depends on the scope of the information requested by the commissioner. If the scope is unclear, it just says, please give us some records, then I think for the provision of such information, maybe under the magistrate's warrant, then the magistrate would have taken into account whether the types of documents required is necessary. So there is a safeguard there. There is a safeguard before a warrant is issued by the magistrates. So then I think it is not up to the individual operator to decide by themselves whether they want to redact some of the information or delete some of the information. So I think this is the major principle. More importantly, even during this process, for the information provided, some of them may be confidential. Then I think it is still governed by Section 57 of the bill concerning preservation of secrecy. So the system has already put in safeguards. Thank you. Next, Mr. Lai Tong Kwok. Thank you, Chair Lady. I think the administration has tried their best to explain the situation. But I think the administration has talked about principle and the policy. But under the bill, I can't find any provision or requirements specifying the power to be exercised by the commissioner under the bill. So is the commissioner bound by the points you raised in paragraph 5? That means he's not targeting personal data or commercial secrets. The administration has explained that the operator cannot decide on their own subjective idea whether to provide such information. But for the commissioner, they ask for the personal data, and you have to provide it. So that's two sides of a coin. So I think the administration should go back and consider how the policy stipulated in paragraph 5 can be stipulated in the bill so that everyone will understand that there is this constraint, so that when the commissioner asks for information, they cannot ask for personal data. Otherwise, they would have to go to the court or judicial review. That would be very messy. Deputy Secretary, Mr. Leung, can you please explain this clearly? Your principle is not to target at personal data and commercial secrets when you ask for provision of information, but you do not rule out the possibility that the information required may contain such, and such information is protected by Section 57 of the bill. Can you explain a bit more clearly about that? Thank you, Mr. Lai, for the question. For the bill, the policy objective is to regulate the security of computer systems. So this is rather a technical issue in it does not concern personal data. So we have explained that our policy objective is not to target at personal data, but under the bill, we cannot spell out such a principle in the sections because we have taken into account relevant legislation in other jurisdictions, and there is no such arrangement in such a legislation overseas. Mr. Leung has explained that information to be solicited are governed by the legislation. So it is not a subjective requirement of the commissioner to target at a certain operator and then ask for the provision of information relating to personal data within the operator's organization, because the commissioner has to exercise a function under the bill, and it is stated clearly in the bill the functions of the commissioner. So there is already a regulatory framework. As we have said earlier, after the information has been contained, they will be kept confidential. So there is a very stringent requirement. So we think that the mechanism is adequate to reflect the policy intent, and there is no need to specifically have another provision regarding this, because there is no such similar provision in overseas legislation. Also, we may be ruling out the commissioner's responsibility to discharge his duties in future. As I've just quoted an example, he may have to ask for information which may touch upon personal data and commercial secrets, so we cannot rule out these in the legislation. Otherwise, we'll be confining the commissioner in discharging his functions and duties. Ms. Doreen Kong, a follow-up? Yes, Chair Lady. I would like to help the administration, actually. The administration has pointed out that under Section 57 of the bill, there is a provision about preservation of secrecy, and that's adequate. And there is no similar provision in other legislation to spell out how the personal data or commercial secrets will be protected. But I would like to assist the administration. I want to point out that in the case of Singapore, for the Cybersecurity Act 2018, they have a Section 43 there about preservation of secrecy, which is similar to ours. But in their section, under subsection 8, it is stated clearly that if their commissioner requests for disclosure of information, they have to take into account several factors, including whether there is commercial secrets involved and whether they will endanger the reasonable commercial interests of an operator, and also whether the private affairs will be affected. So they have to take into account whether the disclosure of such would affect the personal interests of the person concerned. So the commissioner has to take into account these factors before they ask for disclosure information from the operator. I do understand the principle of the administration and have no doubt about that principle of the administration. But if you don't spell it out clearly, then it may be problematic because there is such provisions in other legislation. They are available there. So there may be some companies which would have concern. So I would really urge the administration to go back and consider this point. I'm just saying that when the operator provides the information, can we say clearly that the commissioner has to take into account a host of factors, as in the case of Singapore? Thank you. Thank you for the comments. We'll go back and consider that. Please continue. We move on to paragraph 6, the summary of views. There is a comment that we should state clearly the definition of critical infrastructure and also the timeline for the COI to comply with the requirements and the content of the written instructions. For the bill, we have already have a clear definition of the term of critical computer system in section 2, and for the three categories of obligations to be complied by the COI are stated in Section 4 and Schedule 6. On the written notice, Section 7 of the bill has already stated out that the regulating authorities can issue written notice under certain circumstances. So we think that the bill has already covered these areas clearly. Thank you, Chair Lady. Please continue if there are no questions from members. Next, we move on to the third-party service providers, paragraph 8. We have touched upon that earlier. If the third-party service provider is stated overseas and there are certain requirements there and they will not be able to comply with the requirements in the bill, we are saying that there may be different systems in different jurisdictions. We will try to provide the details in the code of practice in future. And we just say that they can outsource the service, but they cannot outsource the responsibility. So the COI has to comply with the requirements under a bill, and they can make use of the excuse that there is a difference between the requirements here and overseas. Mr. Lai has a question. Yes, we have discussed that for a while, but I want to clarify one point. My understanding is that the organization providing this comment would like to say that if the third-party service producer is in a different jurisdiction and their jurisdiction has different requirements as compared to Hong Kong, when there is a conflict, then they want to say if they don't comply with the Hong Kong requirements, then you will sue me. And then they can use the reason that they are not allowed to do so under a foreign legislation and use that as a defense. The Deputy Secretary has given a response. I just want to confirm that the government will not allow that to be used as a defense. Is that correct? So you're saying that if they operate in Hong Kong, they would have to follow the Hong Kong laws first. For the overseas legislation, they will have to sort it out themselves. I just want to confirm, is that the case? This is actually a question raised by the submissions. So what do you think about this? Please state clearly. Deputy Secretary. Thank you, Mr. Lai, for the question. On this point about defense, for the bill, we have actually provided 2 levels of defenses. If they have to comply with the category 1 to 3 obligations, they can use due diligence as a defense. And for other offenses, they can use reasonable excuse as a defense. So we do not have plans to provide other defenses to deal with the situation when there is discrepancy between the legislation in Hong Kong and that overseas. We do not want to add a new provision, but for the individual cases, then I think we have to deal with that individually and see whether the court will accept the situation. So our policy is that we will not use the contravention between the different pieces of legislation as a reason of defense by the operator. So your short answer is that Mr. Lai's understanding is correct? Yes. So you already have the due diligence and the reasonable excuse defenses, but you cannot make use of the reason that there is discrepancy between Hong Kong and overseas legislation as an excuse not to follow the Hong Kong laws. Is that correct? Yes. Please continue. I move on to Part C. For the summary of views, is that they ask how we are going to define a critical service and also the scope of critical computer system and whether we should allow for a grace period. Our response is that following the commencement of the bill, we would have a clear Section 2 which lists out the definitions, and we would use that as a reference point to see which systems comply with the requirements as a critical infrastructure. Also, we will take into account the factors stated out in Section 11 as to whether it is a critical infrastructure. Moreover, we will also look at the operation of the operator and see whether they rely on the computer in order to specify that it is a CI operator. And also, we want to see whether the system should be specified as a critical computer system. When we move on to the clause-by-clause examination, we can point out that in Section 11, 12, and 13, there will be factors for consideration. They are stated in the bill as to how to define critical computer system, etc. On the grace period, we have talked about that. Following the commencement of the bill, we will use a risk assessment approach, and depending on the operator's state of readiness, we will have the specifications stage by stage, and we would allow sufficient time for the specified CI operators to prepare for themselves. So we will not provide any further grace period in the bill. Mr. Lai, you have a question? Yes. 2 questions. On paragraph 11, it is stated clearly that the commissioner and the designated authorities will take into account whether a system should be specified as a critical infrastructure. There are certain steps. It is stated clearly. But in the bill, I cannot find the relevant provisions. So for the procedure or the steps that you have outlined, how are you going to put that into place so that the designated authorities and the dedicated office will act accordingly? That's the first question.
The second question is a concern. The second issue is the concern of a organization that has submitted its views. It said that those who are ascertained to be CI operators should have been given sufficient time for preparation. So it should have
situation from the organization that has submitted such comments. They may run different systems. They may not be able to get everything done very quickly across different systems. Do they have sufficient time for preparation? Well, people have different views as to the sufficiency of preparation time. So they would like you to see a line drawn. I hope the administration would make it clear how you can very clearly lay down something that you will certainly give them sufficient time for preparation. That's important. If this is put down as suggested, they will be assured. Deputy Secretary, thank you, Madam Chair. Thank you for your questions, Mr. Lai. On the first question, and that is in paragraph 11, we set out certain steps in the procedure to ascertain certain critical infrastructures or designating CI operators and critical computer systems. Actually, in the bill, it's actually in part 3 or clauses 11 to 13. So we have to, first of all, ascertain critical infrastructures and then proceeding to clause 12, designating CI operators. Therefore, in the bill, we already talk about the ascertaining of critical infrastructures, and we follow by designating CI operators. Because if some infrastructures are not ascertained or designated as critical infrastructures, you cannot ask for anything more from the operators. And therefore, we can move on to clause 13, designating critical computer systems. In this clause, we set out that for the purposes of this ordinance, a regulatory authority may, by written of a notice to a CI operator regulated by the authority designating a computer system that is accessible, etc., by operator in and from Hong Kong. So we have to first of all designate a critical infrastructure before we can move on to designate a critical computer system. So that's the way the bill or the clauses are drafted. So there's no need to set out the procedure in the form of step 1 and step 2 and step 3, etc. Because it's a progressive approach. You can only move on from designating critical infrastructure and then designate operators and critical computer systems. As regards whether sufficient time will be given to the operator for preparation. Well, because we have been in communication concurrently with the trade, notwithstanding the fact that this is still a bill, they would know more or less the framework of the future regulatory scheme. So we would be communicate with them further so that they can make some preparation now in the light of the future framework, regulatory framework. Well, the bill may only come into effect or fully commence next year because we have to set up the designated authorities and the specified offices. As for whether we are going to have, or the Commissioner's office, as to whether we're going to have give them 2 years. Actually, we started the consultation and communication back in 2023, and after the bill is enacted, there will still be another year. So more or less, we have already allowed that grace period requested by the trade. And also on the policy level, we have indicated to this council that sufficient time will be given for their preparation. But will there be individual cases where they find some special difficulties? Well, we can deal with those on a case-by-case basis. Thank you. Mr. Lai, I just want to make one clarification. I'm not asking you to specify in the law all the steps in the procedure. That's not what I want. In the future, the designated authorities or the commissioner's office should issue a paper, a document, setting out clearly what he would do, what the steps he would take, and everyone would know what would involve, what's going to happen by reading the document. And you have to tell the parties concerned that you would do this, and they would have certain expectations. Thank you for your comment. We'll follow up these suggestions properly. Mr. Ngan Menyu, I have, 9.4 of paragraph 11, it said that they would, we will understand whether the computer system which the operator relies on in providing service fulfill the definition of the relevant clauses. Are you talking about doing this every time you have a different operator, different system? For example, do you have to ascertain whether Microsoft Office is a designated computer system? Well, there's a duty to make a report that is under clause 22 to the commissioner's office whenever there are changes to the system. We do understand that computer systems are subject to regular updates, and the operator may also acquire new equipment or install a new system. In this case, there's an obligation to make a report to the commissioner's office. What do you mean by significant changes? Well, actually, you can refer to clause 22 bracket 3. There are some examples of material change is described. If the change affects the computer system security of such a critical computer system, for example, some security-related device has been installed which would affect the overall security of the computer system, then the report is warranted. Secondly, if the change would affect the operator's ability to respond to a security threat, then a report should be submitted. Oh, no, it's not my turn. Deputy Secretary, when I read this particular part 3, that's ascertaining CIs, designating CI operators and critical computer systems, clauses 11, 12, and 13. So that would involve ascertaining whether certain infrastructures are critical infrastructures, and then you designate CI operators, and the CI operators would then have to make sure that they are operating designated critical computer systems. When you designate a CI operator, would they know what computer systems under their control would be designated as critical computer systems? From past experience in communicating with the trade through working meetings, for potential CI operators, we would try to ascertain the core services or core computer systems that they are relying on in providing their service. And once the bill is enacted into law, and then we would, in respect of a potential operator, through the continual communication, we'll understand what computer systems are relied on by them in providing their core functions. So procedurally, we have to ascertain whether they are critical infrastructures, and then whether they are critical computer systems under the operator. But this would be a very quick process. We would inform the operator in writing and very quickly, since we have had some communication in the past with them, so we will know which critical computer systems would be covered by clause 13. So very quickly, or we can do things concurrently after informing the CI operator that in writing that he has been designated. We will be able to ascertain or designate their critical computer systems. Much will depend on whether the CI operators understand the core services that they are providing and what computer systems are relied on in providing such services. Well, I will not rule out that these steps will be carried out at different times, but that would depend on individual cases. Please continue. Part D. How do you define an incident and a notification require? There's a view that we should make clear the reporting time limit for incidents, or to provide clear definition of incident. Well, we are talking about a material adverse impact on a critical computer system in respect of the definition of incident. So that the access, availability, integrity, and confidentiality of the computer system may be affected, and also it would compromise the ability to resist threat, and also in respect of the damage caused. And under Schedule 6, it said that the security incident means that it's very likely to interfere with the core functions of the relevant critical computer system. So that's in respect of incident. And also, we also set out the time limit for making a report. I just want to put down a note. I would go to details when we proceed to that part in the bill. You'd say this is quite straightforward. I doubt it. Whenever there's a security incident, well, you have to make a report. When it's happening at a time, you have to make a report. You are talking about something that is likely to disrupt the core functions, but actually a report is required before the disruption is caused. How can people judge that is likely to happen? If they subjectively think that it's unlikely to cause the disruption, but then later, with hindsight, you think that a report should have been made because it was considered likely to disrupt the core functions. But so that's really a case of my words against yours. I would go into a more detailed discussion when we proceed to that part in the bill. Well, that's agreed. When we proceed to Section 20, Clause 28 and Schedule 6, we will be looking at the relevant terms, and then we would have some discussion. Please note this, Deputy Secretary. Please continue. There are views that there should be a precondition that to the best of the knowledge of the operator in respect of the notification responsibility. Well, actually, under Section 65, if they do not comply with the responsibility for Category 1 to Category 3, and there's a defense, for reasonable endeavor defense, if he has taken everything to the best of his abilities to prevent the relevant criminal offense, then that would be a defense. So we can consider that we can incorporate this element of to the best of knowledge of the operator in that particular defense instead of putting it under another category. Please continue. There's a suggestion that the time limit for making a report should be up to 72 hours because there is a concern that the operator may find it difficult to comply with the time limit. Well, actually, we have already relaxed the time limit from 2 hours to 12 hours. And this requirement, this time limit, is the same as that for Australia, and it's a much more generous than Singapore's and Macau's requirements. Please continue. E, the functions of the dedicated authority and the commissioners of office responsibility to deal with computer system threats. The power of the office and the commissioner's office in dealing with threats. There are views that the office has too extensive powers, and we hope that some check and balance can be incorporated. Well, we believe that the powers will be limited to ask the operator to submit information or answer queries. If we ask the operator to, under investigation, to do something else, then the commissioner must be satisfied that the relevant conditions are fulfilled. And if access to the operator's premises is required, then the magistrate's warrant is required. As for other suggestions, as for the parties other than the CI operators, as they are not the target of regulation under the bill, we have to suggest a much more stringent threshold, and so that the commissioner in dealing with computer system threats or incidents must be authorized by a magistrate by issuing a warrant before he can act. On the other hand, we believe that the powers are already strictly restricted for the purpose of entering certain premises. We have noted that other jurisdictions such as Singapore and Australia, their laws do not require the authorization of the judicial authority to conduct investigations. So we believe that we are already imposing a much stricter procedure than other jurisdictions.
有問題。
Dr. Frankie An. Thank you, Madam Chair. I'd like to ask organizations that are not CI operators, why is the Commissioner tasked with the relevant investigation? Why shouldn't other departments carry out the investigation? I'd like to seek clarification from the DS. Thank you, Madam Chair. Thank you, Dr. Frankie An. In general, in the event of an incident apart from the operator, which is our investigation target, computer system may be connected to other systems. This is common. Perhaps the operator uses service provided by a third-party service provider. In this case, when the computer system is connected to another system, or when a service provider is providing service to an operator, the service provider isn't our regulation target, but in case of an incident, the Commissioner may ask the relevant unit to provide information to ascertain the cause of the incident or to implement appropriate measures in order to contain the incident. This is the situation to which we are referring. That is also one of the powers of the Commissioner. It is the Commissioner's responsibility to handle computer system security incident. In the case of other criminal events, other law enforcement agencies will take part as well. Thank you, Madam Chair. I'd like to ask the DS, put yourself in another's shoes. Assuming you are an organization and someone claims one is a commissioner and has to investigate, what would you feel? I have the paper right now, then I know that person is a commissioner within the Security Bureau. But what about an ordinary organization or an ordinary citizen in Hong Kong? He or she doesn't know what a commissioner is. From the perspective of execution or implementation, in relation to organizations not under the regulation of the Commissioner, should the Commissioner handle the case together with other people, other personnel? Thank you, Madam Chair. Thank you, Dr. Frankie Yan. Those responsible for carrying out investigation may not be known to all members of the public. In Clause 53, the Commissioner might not go to investigate himself or herself. He or she might delegate other officers to carry out investigation. In case of any suspicion, doubt, they can require the authorized officers to produce the warrant or documentation to show that those persons are the specified officers. This will ease their concerns. That is, someone proclaiming someone is the Commissioner or a specified officer. Next, going to F, designated authorities. There are views that the Commissioner's office and the regulators in some industries might have duplication in their functions and powers. Better coordination is required. Under the bill, we have two designated authorities. That is the Monetary Authority and the Communications Authority. They are required to perform Category 1 and 2 obligations. The Commissioner's office is responsible for monitoring and regulating the Category 3 obligations. As the regulating authorities, these authorities have clear division of work. We expect when the bill comes into operation, the Commissioner's office and the other authorities will maintain a close dialogue in order to make sure there is consistency in relation to the standards and the streamlining of incident reporting mechanisms. Mr. Ng. Thank you, Madam Chair. I completely understand the concerns of the industry. As regards Category 1, 2, 3 obligations, they are interlinked. For example, in relation to cybersecurity, one may have to deal with the Commissioner's office and another authority. That is the industry that they operate in. So my question for the DS is, in the future, when the ordinance takes effect, how can you make sure seamless communication between the two authorities? My another question is related to this one. Isn't there a special team responsible for implementing this ordinance? DS. Regarding designated authorities and the Commissioner's office under the bill, designated authorities are only responsible for regulating the organizations within their purview inside their industry. And they are only responsible for Category 1 and 2 obligations. The Commissioner is responsible for Category 3 obligations. These obligations may be interlinked. In the future, in the implementation of the ordinance, there will be sufficient communication, so there won't be double regulation. Category 1 and 2 obligations, designated authorities, and Category 3 obligations, the Commissioner's office. When the ordinance takes effect, our idea is that MOUs can be signed among the Commissioner and the other two authorities. I understand the authorities take legal action based on some areas of legal action, law enforcement. Well, we can relay Mr. Ng-Kong's view. In the drafting process of the bill, we liaised with the team of the two authorities. We had discussion, and in the drafting process, we met with the industry. We worked together on the bill. They may not come from a dedicated team. They have other responsibilities to perform as well. But there is already a team taking part in the drafting process of this ordinance. We will relate members' view to the relevant unit. Thank you. Mr. Ng-Kong. In Part 4, Division 3, we can look into this area in greater detail. In relation to Category 3 obligations, some safety incidents only need to be reported to the Commissioner's office. How can we ensure coordination and communication among the Commissioner and the two authorities? I will ask this question when we come to that. Do you mean regulating authorities? Yes, that's my question. We'll discuss this point when we get there. Thank you. Ms. Elizabeth Cott, I'd like to ask about the designated authorities. Some organizations should be designated authorities. See the SFC, the MPFA. Designated authorities will have to prepare in relation to manpower and so on. So can the government consider our views? Apart from the two regulating authorities we have right now, will the administration make more authorities as the regulating authority? Thank you, member, for your question. In paragraph 24 of our reply, we were asked whether we will designate other regulators as the designated authorities. In addition to the two authorities set out in the bill, we are concerned about the factors that will be taken into account, including the main functions and powers of the Commissioner's Office, as well as the number of potential operators and the scope of regulation. Have regulating authorities issued guidelines on the safety of computer systems? And in general, when we have regulating authorities, can we more effectively achieve the aim of this bill? There are statutory regulating authorities. Some have requirements in relation to computer system safety. So based on the basic requirements, we welcome any other requirements that are aimed at improving the safety of computer systems. By way of subsidiary legislation, the Secretary for Security may designate an organization to be a designated authority. Well, the DS said in the future she might consider members' views. Does it mean that at present you will not consider? From 2023, we started to have communication with the industry. We also talked to them about regulating authorities. At present, we find that the two units as set out in the bill are suitable to be designated as regulating authorities, but we'll keep in view the situation. If need be, we'll add more regulating authorities. Well, I know I'm repeating the same point, but I still have to say this. Say the role of the MPFA and the system of MPF. How critical is it? The asset of many members of the public are within the MPFA. If the MPFA isn't a regulating authority or a designated authority, I don't quite understand this point. Why is the MPFA not on the list? What is the reason behind this? DS? Thank you, Ms. Kwok, for your question. The computer systems of the MPFA if they meet the legal requirement as a designated authority, they may be appointed as a CIO. As the operator of a very critical infrastructures, this practice is actually applicable to many industries. It's being implemented in different industries. The MPFA manages the MPF platform. We understand the implementation hasn't been fully completed. We'll wait and we'll see whether it should be designated as a CIO. One of the concerns is the number of potential regulators. Operators. If need be, we don't rule out the possibility that we may add more authority to the list of regulating authorities. Well, I'm none the wiser. Why shouldn't it be included right now? These systems are managing the asset of Hong Kong people. They are critical to the elderly care system in Hong Kong. So whether the system has been completed, we do need to look into the ways to enhance the support for the elderly. So I hope the administration will take on board my view, that is to add MPFA to the list of critical infrastructures. I'll let Mr. Ronald Chan ask the question first. Thank you, Madam Chair. Well, I wanted to ask this point later on, but now that many people are asking about this point, I'd like to speak right now as well. In the case of MPFA, probably the computer systems haven't been made available, but the MPFA shouldn't be self-managing itself. Whether the Communications Authority or the operator, they operate the relevant activity as well, so it might be more appropriate for them to be made the regulator. There are other important financial systems. One, FPS. Hong Kong ICL is responsible for managing FPS. $710 million in Hong Kong last year. Hong Kong ICL is co-managed by the Hong Kong Monetary Authority and the Banking Association of Hong Kong. Well, when a regulating authority is a shareholder, is it fit for that authority to manage the operator? Shouldn't we designate one authority as the designated authority? SICAS, which is close to the heart of Mr. Robert Lee, is managed by the Hong Kong Exchange as well. So, which organization or body should manage SICAS? Should it be managed by the SFC? Well, it doesn't sound to me that it should be managed by the SFC. It may fall under the purview of the commissioner. So you may want to set out clearly in the bill. So I agree with Ms. Kwok. For important systems, why do we have to wait until later to introduce subsidiary legislation? Why can't we prepare right now, setting out all the critical systems? You have payment tools, you have FPS, SICAS, and these are critical systems. If EMPF hasn't been made available yet, you probably don't want to add it right now. But what about other tools? We need to prepare early, so when the ordinance takes effect, the provisions will be clearer. Thank you.
Deputy Secretary, would you like to listen to one more member's views first? Mr. Robert Lee? Well, Mr. Ronald Chan has talked about the Hong Kong ICL, and the SFE governs the whole capital market of Hong Kong. It is very important. I think from the view of the industry, we want certainty. If you don't mention about them, then maybe we don't have to make certain preparations at this stage. But if you leave a gap here to say that they may be included in the subsidiary legislation in future, does that mean that that will be done, but we don't know about the timing yet? Then that will be some uncertainty for the industry and the trade. So that's why from the perspective of the industry, we would like to have certainty. For the designated authority like the SFC or the stock exchange, they have their own regulatory systems, and they have their codes of practice and also their requirements that need to be complied by the companies concerned. So I would like to know what is the administration's objective. I've been attending several meetings on this bill, and you're saying that they are not a designated authority at this stage. But following discussion, you can notice that members have concern and think that these are important organizations, and the capital involved and the number of staff involved is great. So I hope the administration can let us know more about your current plan. Are you going to include these organizations as designated authorities in future, or you're not going to do so? So I think the industry would like to have a clear understanding so that they can make the necessary preparations. Thank you. On this, I would like to add my personal observation as well. 3 members have talked about the governing of the financial and banking sector. This is definitely one of the sectors under Schedule 1 of the bill. Mr. Ronald Chan want to discuss this about the designated authorities, but I think maybe now is a suitable time for discuss this matter here. Well, this is something dynamic. The process is dynamic. Once we have commenced this views committee, there are several members, including Mr. Lai, Ms. Kwok, and also 2 members from the financial sector, have pointed out that for the banking and the financial sector, we would like to have more certainty. For the MPFA, I think the eMPF is owned by the MPFA. It is an operator, but then it is also using a third-party service provider. As Ms. Kwok has pointed out, they are dealing with the MPF schemes of a lot of citizens in Hong Kong. So can you give us some certainty? And don't use the subsidiary legislation as a means to designate future designated authorities. For the eMPF platform, it is important. Well, you have listened to Mr. Chan's view as to whether the MPFA should be designated as a DA. It may be a bit tricky because it owns the platform itself, it's an operator also. For the CMU and Seekers, these are also different kinds of systems dealing with a lot of clients. Well, during the transitional period this year, we hope that the parties concerned will be ready. And thirdly, Mr. Chan has pointed out whether the Monetary Authority is also suitable DA because they own the Hong Kong ICL jointly with others. So can you let us know your position on this? Well, thank you, Chair Lady, and thank you, members, for your comments. I think we have talked about a number of systems, and these computer systems are very important. We have no doubt about that. And under the bill, we would have to consider whether these systems will be designated as a critical computer system, and that is spelled out under Section 2. And it is stated that for the critical infrastructure, there are factors to be considered. That means if it is continued continuously affecting the essential service stipulated in Schedule 1. So when we consider the matter, I think this is a critical definition that needs to be taken into account. So the systems mentioned all fall under Schedule 1 under the financial sector. As regards the different organizations, I think we want to see whether we want to designate them as designated authorities. Apart from the monetary authority, like the NPFA or the Hong Kong Exchange and the SFC, they are not designated authorities at this moment. So if they have an computer infrastructure and they do not fall under Schedule 2 of Section 2, then under our regulatory framework, these important computer systems will, if they fall within the definition and they are operators, then they will be regulated by the Commissioner. So we have certainty here, because now they are not under Schedule 2. So that means all these important facilities, if they fulfill the requirements, they will be regulated by the Commissioner under the bill. So this is point number 1. Secondly, we have talked about the monetary authority. They fall under Schedule 2 of the bill. So the monetary authority, it is a designated authority. For the Interbank Clearing Limited, the platform, it is also fulfilled the requirements under Schedule 2. So in future, if they fulfill the requirements to be regulated, then that means the payment system, they will be one of the organizations to be regulated by the monetary authority, and they are owned by the MA. The question is whether they can be directly regulated by the MA. Well, even if we don't look at this bill, under the current situation, so according to the Payment and the Store Values Ordinance, there is already a list of regulations regarding the governing of these systems. And they have taken a lot of measures to deal with possible conflicts of interest. In future, if they carry out the duties as a designated authorities, they will rely on the existing arrangements to prevent the occurrence of conflict of interest. For the Hong Kong MA, they have clear delineation of responsibilities, and also they have enhanced transparency regarding regulation. And in 2024 December, the Chief Executive has set up a review committee, which is not statutory, to review the regulation standards imposed by the Hong Kong MA to ensure that the systems adopted will be aligned with the same standards as to whether it is owned by the MA or not. So there are several ways to ensure that the matter is clear. So whether the MA is going to regulate the clearance platform, this is what is happening at now, and we have a prevailing method to ensure potential conflict of interest. In future, if need be, we would use subsidiary legislation to include them in Schedule 2. As I have mentioned before, all the important systems mentioned by members, if they are important and they fulfill the requirements to be regulated by this bill, and if they are not included in Schedule 2, then in future they will be regulated by the commissioner. So I hope that this will give members a clear understanding about the delineation of responsibilities. Mr. Ronnie Chen, do you have, or do you want to let Mr. Ma Fung Kwok ask first? Yes, Mr. Ma. Thank you, Chair Lady. Well, I would like to ask a question which is not directly related to what we are discussing right now. We may have major social events or sports events or performance venues. And for example, like the Kai Tak Sports Park, it is a major venue hosting a 50,000 audience, and there may be participants, staff, and the performance sector. We may have up to 60,000 people, so there may be a lot of risks. For example, there is a central ticketing system, and then also on the management of the various venues may create problems. I think the risk may be different from that of the financial sector. A lot of the risks are very imminent. For example, if you have a lot of people trying to enter premises, there may be problem if they can't do so. So you are saying that they should report an incident within 12 hours, but within 12 hours, a lot of things can happen. So I think time is of the essence. It is an important factor. Also, for the regulator, they may include the government departments like the LCSD, or they may include service providers or different organizers. So under such a scenario, if we try to put that into context of this bill, so there is no particular regulator. You only have a department which is regulating the relevant subject matter. So how are we going to implement the regulatory measures and to manage the risks? Deputy Secretary. Thank you, Mr. Ma. Thank you, Chair Lady. When we're talking about major sports venues, according to the bill, if they fulfill the requirements to be designated as critical infrastructure, that is Section B, because they do not fall under Schedule 1, they are not of a particular sector. But if there is damage and there is leakage of personal data, or they cannot function, and it will not be possible to maintain economic and societal operations. So Mr. Ma has talked about the major sports venues. I think they fulfill this definition. And we would also take into account whether they would fulfill the requirements in Section 11 of the bill. In future, we can include the relevant sports venues as a critical infrastructure, and they can also be designated as CI operators. If it has been designated as a CI operator, then they would have to follow the requirements stipulated in the bill. That means they will be governed by the commissioner. Mr. Ma has pointed out that there may be regulation from the Policy Bureau at the moment, but this is only on the policy perspective. But if they make use of computer systems to support their core functions, for example, like ticketing or other related operations for the venue, then they may also fulfill the section, the requirements to be set out as a critical infrastructure. Then they would have to follow the requirements stipulated in the bill and fulfill their obligations. Thank you, Chair. Mr. Ma, well, I fully understand that, but that's not the focus of my question. My question is that if something happened to these events, there will be imminent risk. There will be imminent security risks and public order issues. So I don't care about how you're going to make the operator to report on the incidents, but how are you going to tackle the incidents? We just talk about one of the sports venues. Actually, we are not just talking about a lot of different systems. For example, like the ticketing system optics, it covers a lot of sports and different venues. So if something happens to this system, several dozens of venues will be affected. So how are you going to deal with the matter? You are now extending the time for reporting from 2 to 12 hours, but that will not be able to deal with the matter. So my concern is not how to report and how to take remedial measures, but if something bad happened, how can the commissioner take immediate action to deal with the incident? So, Deputy Secretary, for this scenario mentioned by Mr. Ma, can you give a response? Well, thank you, Mr. Ma, for raising the scenario. Well, according to the bill, the commissioner, as I have pointed out, if there is incident concerning computer security, and you also mentioned the computer systems may be linked together, then under the bill, when we designate the critical infrastructure and the critical infrastructure operator, if there is interface or linkage amongst the computer systems and something happened to one system may affect the others, then they will fulfill the requirement to be designated as critical infrastructure. Then all the computer systems will be governed. So this is point number one. Under the bill, our requirement is that we do not want to have reports of incidents after the incidents have happened. We have preventive measures. We have computer security drills. We have computer security management plans. We have computer security audits. So we hope that with all these, we will be able to reduce the number of incidents happening. If unfortunately a computer security incident happens, then we require them to report within 12 hours. So less than 12 hours, they should report the incident. And in the interim, the commissioner can exercise early intervention. So we hope that as soon as possible, whenever there is a computer security incident, we can try to deal with the matter. To deal with the matter means how we are going to revamp the reboot the system and to prevent the spread of the incident to other systems. So we're trying to look at the computer system security issues. If the scenario Mr. Ma mentioned happens, there may be a lot of people affected. We may have to disperse them. There may be crowd control issues. And so there may be physical crowd control matters that need to be taken into consideration, and that is not under the purview of the commissioner. We now have conducted a lot of drills. For the moment, we don't have a lot of operation in place yet. If for a major sports venue, the audience can be dozens of thousands of people, and the government will conduct physical drills, and these do not concern the computer systems. Under the bill, we want to use preventive measures, and for the physical order to be conducted is not under the commissioner. He only dealt with computer system security. Mr. Ma, is your question answered? I don't think the matter has been resolved. So, Deputy Secretary, you're now saying that like the Security Bureau and the enforcement departments will be responsible, but this is to deal with the aftermath. My question has not been fully answered. I think the Deputy Secretary is trying to explain that for critical infrastructure, subsection B, there are requirements to consider whether they should be regarded as critical infrastructure. I think the Kai-Tak Sports Park is our biggest sports park now, and goes without saying it may be regarded as critical infrastructure. I think the DS is trying to say that if it is designated as a CI, they will have different obligations like Category 1. There will be preventive measures that need to be taken into account like drills, etc. As regards the response, these will be taken under Category 3 obligations. But there may be other emergencies, as mentioned by Mr. Ma. Like the Kai-Tak Sports Park, we know that there are drills going on and there will be drills tomorrow. So I hope that you will bring back Mr. Ma's concern and consider how you're going to deal with the code of practice in future.
Thank you, Madam Chair. Ms. Elizabeth Kwok and Mr. Chen Chen-ying are going to ask follow-up questions on the same issues. So, Ms. Kwok? Well, I pressed the button before the Deputy Secretary gave her answer. I think the answer is clear. At least we know. We know now that EMPF and other relevant platforms are not designated, or their regulators are not regulated, then these relevant incidents will be regulated by the Commissioner under the bill. I wish we had got the answer earlier so that we would know earlier that this would be the case. Because we are concerned about security risks to our critical infrastructures. The earlier we know about them, the better we are prepared psychologically, so that we can make available the relevant hardware and software and personnel to cope with such risk. We know in Hong Kong the availability of such personnel is rather tight. So we need to get ourselves prepared in that designated grace period. The trade must get prepared, and they may not be well prepared in terms of manpower availability. So they should start before this bill is passed into law. That's why we have been asking questions about the issues. Thank you for your comments. Well, actually, we're moving in the same direction. We have been constantly in communication with the trade through different meetings so that they can get sufficient time for preparation. Mr. Chen Chen-ying, having heard the Deputy Secretary's replies, we now understand the matter better, but there are technical issues. The destination authorities will have some reporting obligations in the first and second category. The others will fall under the purview of the Commissioner. And they also have the Commissioner's office. Well, you are saying that for financial regulation, it should be done by the Hong Kong MA, and for telecommunication, it should be done by the CA. But I have mentioned some examples whereby there are no designated authorities for them. And then you have to examine the response structures, etc. Well, it would fall under the purview of the Commissioner's office. I'm not saying that they are incompetent, but I think they would find it very difficult to comprehend or to have competencies across such a wide field. But there can be two parties when you designate a designated authority. You can, for example, for banking, you can designate Hong Kong ICL. Although Hong Kong MA is a shareholder in that in the HKICL, well, you can designate that to be authorized authority, so that the matters will not be left entirely with the Hong Kong MA. And also, EMPF platform is managed by the MPFA. So perhaps the regulation should be done by both the MPFA and the Commissioner's office, so that no single party can make all the decisions in regulation. I mentioned seekers. But you can also ask the SFC to be an authority. So we should not make it a hard and fast rule that there's only one designated authority, then so that we can avoid a situation whereby in the future the commissioner's office would request staffing with personnel that would cover a wide range of disciplines. We really need to ensure that regulation is a balanced regulation. Mr. Chen has made a suggestion. I think it's worth your while to give it consideration. It's okay if you cannot respond right away here, because this is a major suggestion. This is an important suggestion. HAICL also manage AMU and other relevant facilities, critical facilities. Any response here and now? Well, first of all, I would certainly consider the suggestion, and we also keep things under review because the situation is a dynamic one. We do understand that, as we can see in Schedule 1, there are 8 sectors. Apart from the 2 which are under their respective authorities, the other will be regulated by the commissioner. And we are going to supplement the regulation with a COP. We don't rule out that for each particular sector, we will have some sector-specific regulation. As we set out in paragraph 25, we do not rule out that in any particular sector there may already be a regulatory authority, and of course they know their business well, but we have to make sure that there is a balance, regulation, and the proportionality. Some regulator may not have to regulate or oversee the operation of many different facilities. It may not be ideal if we allow all the 8 sectors to be regulated by their respective regulatory body. We have to ensure the proportionality and the uniformity of regulation, so that we have a situation where all the sectors will be regulated concurrently by the commissioner and their regulatory body. We want to ensure consistency in the regulatory framework. Ms. Doreen Kong, I agree with Mr. Chen Ying and Ms. Elizabeth Kwok, and I share their concerns. Why have we got so many questions? First, it's because in the bill, some of the duties are discharged by the designated authorities, some by the commissioner's office. And having heard Mr. Chen Ying's comments, I suddenly realized that we need to ask what other jurisdictions are doing in this regard. Do they have a commissioner's office or is equivalent on top of the ordinary regulatory bodies to do this? Are there similar arrangements? If not, then you may say that Hong Kong is in a unique situation. We want to do things our way, or that's okay. But if you think Hong Kong is in a unique situation, and then you want to that have some designated authorities for 2 particular sectors, then how can you avoid a situation mentioned by Mr. Chen Ying? There may be conflicts between the 2 regulators, and there may be the question of shareholders' interest that they need to consider. Secondly, I've heard from some of the submissions that banking and financial services is a very big sector. In the future, many operations will fall under this the definition of this sector. For example, the insurance companies are also offering financial products, and we have also got fintech companies. They are very concerned, judging from their submissions, that if we just look at Schedule 2 and where you have designated authorities, that there may be a problem of lack of knowledge on the part of the designated authorities, because any bank or financial institutions, they will be regulated by the respective designated authorities. How can you assure the insurance companies and fintech companies? Because they think that the regulators may not be equipped with the requisite knowledge to do the job. All right, perhaps 2 questions first. Deputy Secretary. Thank you, Madam Chair. Thank you, Ms. Gong, for your questions. With regard to overseas jurisdictions, we make reference to the UK and Australian concepts, which are similar, and that is the regulation is not done by one single regulator, and they also have a sort of tiered system or structured system in regulation. For banking and financial services, of course, it's a big sector. In Schedule 2, you can have designated authorities. MA, Monetary Authority, is responsible for the organization in paragraph 4 or column 4 of part 2. For those which are not covered by column 4, A, B, C, D, those will be regulated by the commissioner. So unless the schedule is updated in the future, that will be the case. For the insurance sector, they are not covered by part 2 of Schedule 2. In the future, if we think that in order to fulfill the objective of the bill, and if the critical infrastructures should be regulated, then the regulator, the activities will be regulated by the commissioner. I do understand that in Schedule 2, not all banks and not all financial institutions are managed by the monetary authority. We have just got 4 categories. Are there corporations or institutions which are hybrid organizations? They may be running certain business that will be covered by column 4 or part 2 in Schedule 2. But that's not the entirety of their business. It's just part of it. So who would regulate the activities? MA or the commissioner? Thank you, Mr. Guang, for your questions. As for individual operators, depending on the nature of their business activities, we have to make sure whether it should be properly designated, depending on the operations in question. It may be, there may be a case whereby there will be 2 operators for one particular facility, depending on the nature of the operation and whether the operation will be covered by a certain definition. For the 4 categories under column 4 in part 2, it will be regulated by the MA. Others will be regulated by the commissioner. Well, Deputy Secretary, in paragraph 25, you set out the 3 factors, A, B, C, to be considered by the authority. you mentioned that this is set out in the reply to the Bills Committee on the 13th of January. These factors, are these factors set out in the Blue Bill? Please tell us if it is already there. Whether we're talking about column 4, the regulated organizations, you may consider other organizations that should be covered, such as EMPF platform. And also Mr. Robert Lee mentioned some securities related organizations. Maybe you can give a response in writing or at the next meeting with regard to those suggestions. All right, we'll take a break after this other part, G, Code of Practice G. There are views saying that we have received suggestions on what to cover in the COP. For example, make reference to international standards, maintaining the product neutrality, and also the suggested standards on the risks categorizations of protection of peripheral facilities, setting out the suggested professional qualification and independence of the specified persons, as well as the frequency of drill, the third-party responsibility, etc. In the electrical brief provided to this council in December 2024, actually there is a summary in that on the 3 categories of responsibility. Of course, these can be updated following further consultation with the trade, but we have already set out what would be covered, what activities will be covered. And in the schedule, we have already covered the matters referred to in the consultation. For example, the security management plan for computer systems and what it should cover, and all the way up to bracket G. These are all made in response to the consultations and the views received. We will make reference to international trade standards to ensure that we maintain product and technical neutrality and will not restrict the operator to use specified brands or models or products. And when the organization conduct internal audits, we would set out in the code of practice on the effective measures to adopt so as to maintain the independence of the internal audit exercises. Deputy Secretary, some stakeholders have submitted views that they are concerned that code of practice may adopt a one-size-fits-all approach, and because things can vary from sector to sector. And so can you assure us that the code of practice will have some minor adjustments made for individual sectors? Thank you for your questions. The answer is in the affirmative. Yes, we are going to. Well, we are considering that for different sectors, and in view of their special characteristics and their nature of operation, we can issue different COPs. That's under section or clause 8 of the bill. Is a bracket 9 of clause 8. A regulatory authority may, under this section, issue different codes of practice for different purposes under the ordinance. That is, this is allowed under section 8 on the issuance of codes of practice. So that's the practice with regard to code of practice.
Please carry on. H. Subsidiary legislation. There are views that the industry should be consulted before the contents of this schedule are amended. In fact, we're having communication with the industry to collect feedback from them. So whenever we need to update the contents of the schedule, then we'll collect feedback from the industry. We'll maintain liaison with the stakeholders in case we need to make adjustments to the content. Then we'll consult the stakeholders before we do so. Thank you. Next, in relation to appeal, there are views that there should be more IT professionals sitting on the appeal board. And there should also be members from professional organizations. According to Schedule 7, the CE has to appoint at least 15 members. That is a minimum of 15 members. The CE can appoint more. At least 2 will have to come from the information technology sector. There's no cap. There are at least 2 IT professionals. So can there be more? We've heard from the industry. So in the future, the CE will make recommendations to the CE. We will also take into account the professional background and credentials of IT professionals before appointment. In handling each appeal case, at least there will be one member from the IT professional sector. So there's a requirement that there will be at least one IT professional. Depending on the nature and the contents of the appeal case, we will appoint members with appropriate background to make sure that the appeals are heard in a fair manner. Next, when the operator fails to provide information as requested by the regulating authorities, it is not ideal if the operator must resort to judicial review if the operator doesn't agree. Well, in relation to appeals, we have fully considered the nature of all appeals, as well as the possible impact on the implementation of the ordinance as a result of the appeal. Operators cannot appeal against the request to provide information because that may cause delays in the implementation of the ordinance. The decision of exemption is a statutory responsibility of the Commissioner. There is discretion as to whether this is allowed, and there are also policy considerations, so the Commissioner is in a better position to determine whether the exemption is in the public interest comparing with the appeal board. Mr. Ambrose Lam. Well, whether one can start a judicial review, that will also cause delay. Thank you, member, for your question. One can file a judicial review. Judicial reviews have certain procedures as well as thresholds. Appeal board accepts appeals lodged based on the above-mentioned grounds. For judicial review, there are certain thresholds, and the decision is to be made by the court. If the government is worried that law enforcement action will be hindered, why don't you right away disallow judicial review? DOJ? Well, for the majority of the decisions, they are subject to the challenge of judicial reviews if and except very specialized areas, say national security. In accordance with the national security law, some decisions cannot be appealed against, and these are exceptional circumstances. In general, decisions made by the executive arm are subject to judicial reviews. In some cases, even if it is said that some decisions are not subject to judicial reviews, courts will interpret these provisions in a narrow manner. It is difficult to rule out the jurisdiction or jurisdictional power of the court. Hong Kong is a society with the rule of law. To a certain degree, we allow the executive arm judicial reviews lodged on the grounds of procedural injustice and so on. The statutory appeal mechanism adopts a merit review by the appeal board. In other words, the board can take stock of the decisions made by the commissioner or the regulated authorities or designated authorities. In case of challenges against human rights law, judicial reviews do not replace the role of the organization which makes the decision. And we think a balance has already been struck. Please continue. Last part. Support. There are views that the bill may cause a financial burden to operators. Designated operators are large-scale enterprises. Some of their computer systems already have safety regulations as well as guidelines, so we do not think that the bill will cause a significant burden to operators. In addition, in relation to technical support and manpower support, we have cyberhub.hk from the Hong Kong Internet Registration Management Company Limited. There is also a training scheme on new industrialization and technology rolled out by the VTC Vocational Training Council. High-end technology training is involved. There is also another digital platform of the Hong Kong Productivity Council. There's a wide range of information in relation to information security and cybersecurity. Recommendations are made to SMEs if need be. And these are our consolidated response to the written submissions we have received. We thank those who provide submissions to us. We'll maintain liaison with stakeholders in the industry in order to enhance the level of computer system security. Members, in order to fully express our gratitude to the 18 submissions from individuals and organizations. I've given 2 hours members to discuss it with the administration. We spent more time than expected to discuss the consolidated response, considering the fact that we received the consolidated response quite late. So we'll proceed to clause-by-clause scrutiny soon, and we will also have a simpler session where we discuss the matters arising from the last meeting. Thank you.